Well, new developments as the debate intensifies over how to protect gun ownership rights while reducing gun violence. Several states now anticipating the passage, perhaps, of something, some sort of ban at the federal level, are passing or pursuing their own legislation. In particular, legislation that would say firearms made and then kept entirely within a state's borders, they don't cross interstate lines, would not be subject to any federal regulations. But is that legal? Joining us now, Judge Andrew Napolitano, our Fox News senior judicial analyst. So as I read it, I think about 9 states since the new push for gun control has started have submitted bills that are working their way through these legislatures. But 15 in total have either already passed or are looking at some sort of measure to say, feds, you can do whatever you want. President Obama, you can do whatever you want, but you're not going to mess with Arizona, Colorado, Louisiana, Mississippi, Montana, North Dakota, Nebraska, New Mexico, Pennsylvania, South Carolina, Tennessee, Texas, Utah, Virginia, or Wyoming.
You know, if this were 200 years ago and the Constitution were new and it meant what it said, this legislation would make sense, because at the time Congress only regulated commercial goods that actually passed from one state to the next. This is the so-called Commerce Clause, Congress's power to regulate interstate commerce. But that clause has been so blown out of proportion, Megan, by presidents and Congresses and Supreme Courts, that Congress now legislate almost anything it wants, even something that doesn't move from one state to another, even something that isn't commercial in nature, simply because in some theoretical way, its movement or non-movement might have some effect on interstate commerce.
Yeah, and we saw this in the lead up to the health care debate,
yes,
where the president said the Commerce Clause allowed it, but which, by the way, the Supreme Court rejected. But he based that argument on Wickard v. Filburn, which is an ages-old case. You learn about it in law school, where some guy growing wheat in his own backyard and not distributing it to anybody was said to affect interstate commerce. And so that wheat never left his backyard. These guns will never leave these states. But you tell me, Judge, why would these states be trying to tee up, because that's what some of them say, they're trying to tee up a challenge that would go to the Supreme Court in light of some pretty clear precedent that the federal law will prevail over these individual state laws here?
That's a great question. I think there's probably a couple of different lines of thought behind it. One is that if enough states agree, Congress might back down. Remember, the states can amend the Constitution independent of the Congress if enough of them want to. Another is, it's a different Supreme Court. It's a Supreme Court that twice within the past 5 years has upheld the individual right to keep and bear arms and basically said to states and cities, don't try interfering with that right. So they may very well carve out an exception to Congress's power to regulate interstate commerce when it comes to a fundamental right, like the right to keep and bear arms. But on its face, as much as I love this legislation, and as much as I wish it would be constitutional, it is directly opposed to 60 years of Commerce Clause jurisprudence, which basically lets Congress regulate anything it wants.
But do you see anything in the recent health care ruling? Because President Obama won that case based on his power to tax us,
right,
not on his powers under the Commerce Clause, or Congress's powers under the Commerce Clause, I should say. Is there anything in that decision that suggests a more narrow interpretation of the federal government's abilities to regulate us if we stay within state borders, and perhaps some hope for these states that they'll get a different result? Or maybe they think this court won't see things the way the Wickard v. Filburn court saw things.
Right. Well, Wickard v. Filburn, as you say, is the farmer growing wheat in his backyard. But listen to the rationale that the court used. Because some of that wheat was watered by water that originated in Indiana.
And that's where they're going to go with the guns.